understand that's one of the pieces here of states doing what needs to be done and citizens doing what they have to do. Well, okay, this is a little hard to read, so I'll read it off real quick. Here's some of the things you can do. Ban where the magnitude of harm, if occurs, would substantially harm the public trust, health, safety, and community and property and the environment. Vermont, New Jersey, and New York, as Chris had said. There are some things that ought to be off limits. And then when you move to state lands and the treasure of your state land and recreation areas in this county, I mean, you're talking about something substantial in value, both human and economic, and jobs. And so at some point, there are some situations that should give rise to a ban, even if it's not a statewide ban, like Dr. Roble has suggested. A moratorium until you know the generic impacts. What is the groundwater situation in the state? How many wells are there going to be? What formations are going to be drilled? Why isn't this out for public? Why wasn't this done before these 23,000 acres were leased? Yep. You know, it's the public's land. Yep. And there wasn't any money to be made because, as Dr. Grobel pointed out and Mike Sheldon pointed out, the gas prices is tanked. We're not quite sure if the money will be made. What kind of business person would sell it off cheap and have somebody else make all the profit when the demand and price comes back? And that gets to the public trust of state land leasing policy and the Environmental Protection Act duty to look at all the aspects, the impacts on air, water, natural resources, public use, game, wildlife species. That is the kind of thing that we need to look at to solve this problem. And I would submit that there ought to be a moratorium on permits now that these leases are out. There ought to be a moratorium on permits until this county knows where it's all going. And there are rules at the DEQ that before permits are applied, the DEQ in special circumstances can insist, right? They can insist upon a special hydrocarbon development plan, like the one that's in Pigeon River. The Pigeon River is 50,000 acre. It's bigger than that now and added a lot to it since the Pigeon River oil and gas case. That case went to the state Supreme Court. The state Supreme Court said no. There's not going to be any drilling in the Pigeon River. There was a settlement. 1/3 of it's being drilled. The other is not. So we've been through that process before. We know that we can, in certain circumstances, develop plans that protect the interests at stake. And I suggest that that ought to be something that every community and citizen in this county should be demanding from the state of Michigan before one permit is ever approved. That and the environmental impact studies that duty to find out information. Well, what else can you do? Strategic lawsuits. If the state refuses to do that, then sue to invalidate the leases for failure to consider and determine all the basic information that should have been there to protect the public trust in the Yankee Springs game area and in the Berry game area in the Yankee Springs recreation area. When Pigeon River failed to do that, the Court of Appeals in the Michigan oil case in the mid-70s said the failure to study the impacts before the state leased it was a policy blunder and a violation of the public trust. So, are we going to repeat that again here? And that's what that's the question that has to be asked and answered. And I don't know what the answer is, but it should be asked and answered before these decisions are made. Local ordinances. Well, there's anything from local bans like New York, Pennsylvania, and other states, or resolutions like Yankee Springs Township. Local bans in some narrow circumstances in Michigan might be possible, but the problem you have is under zoning law, the location of a well is exempt. Okay? So you see up there, oil and gas wells, including injection, are exempt from zoning. All right? But, here's the good news, not the adjacent or related facilities such as pipeline, hauling transfer stations, compressors, and industrial type equipment activities and uses. So you've got zoning power here. You just need to carefully look at your master plan, update it if you need to, although that dark green says a lot in terms of what your values are and the state's here. But you update that, you implement special use regulations that are stringent as required, regardless of what the state applies for their regulations on these activities. The other thing is that oil and gas wells and these activities, to the extent that you're talking about activities and operations with risk to the public health, safety, and welfare, every township can pass what are called township police power ordinances to address these effects. Are they prohibitory? No. You can require a permit or a license in your township with standards to protect the health, safety, and welfare. This was done at the beginning of the Antrim Shale development. There was an advisory committee, state advisory committee, when the first fracking started in Michigan. I was on that committee. And we developed a relationship with the DEQ and the DNR, which was one body at that point, and local communities to coordinate land use plans and DNR decisions so that we could figure out what some of the risks were and what were some of the things communities can do. One township, Filer Township, is a great model. They were one of my clients, so I'm proud of them. But we were able to develop a system of zoning ordinance provisions to regulate natural gas and oil wells in Manistee County, and pass township police power ordinances to prevent the risk of what? Hydrogen sulfide. Why? Because the state had permitted a hydrogen sulfide well with 40-some thousand parts per million. And as Mike said, 100 could kill you. At least 400 or 500. And they, a half a mile from the city of Manistee, they permitted a well for 40,000 plus parts per million, thinking it would be handled all right, there wouldn't be a mistake. And the kill zone was like 1 or 2 miles, I forget now, it's been a while. So there was a reason to pass those ordinances, and this township had the power to do it, and the oil and gas industry did not contest it. And they had an opportunity to do so. They complied with it. And those higher parts per million wells were basically off limits because they couldn't pipe or haul it anywhere and meet the standards. So that's the other thing you can do. Then I put here local community oil gas advisory board. Maybe it's a conservation oil and gas advisory board, but a local advisory board that you can, representative of all of you, that creates leverage of negotiation and process and communication with the DEQ and the DNR. It's been done all over the state for years on different situations like this. There's no reason it shouldn't be done. And there is a provision in the Oil and Gas Act that allows the DEQ to require, under special circumstances like here, to require that projects be planned ahead of time. That you figure out where the wells are going to go, where's the oil, what is it, where's the gas, and there is authority where you can demand the DEQ and would do this prior to the issuing of any permits. And that might get you where you need to go with some of this. So, okay, real quick, there's leasable, there's non-leasable, look at the bottom, there's non-leasable land reserve and there's non-development leases like you have. You've got non-leasable, non-development, and development leases. The state has every right to have non-leasable. Why aren't they just calling this non-leasable? Look at how large that area is. Non-development protects the surface, but as Mike said, it doesn't protect developing underneath. And the interesting thing is the DEQ's justification for non-development of the surface is that the oil and gas gets drained by the wells outside, right? And that's valuable revenues for the state of Michigan. So yes, that's an important interest. The difference about hydrofracking is it's not draining. They have to mine under the state land. They're not draining oil out, they're mining under with the explosive busting of the rock, you know, horizontally for up to a mile in some instances. So it's a different situation. So okay, so I guess we'll stop there. Yeah, all right.